Good morning. My name's Ken Gottlieb. I'll be your judge today. It's wonderful to see you all. I want you to know that there will be no trial today. Today is your first appearance. All I'm going to do is check to see if there's probable cause in your case, and if there is, then I'll set a bond. You do have a right to an attorney, and I want you to know everything that we do here is being recorded, which means anything you say can and will be used against you in the trial or motions that you may have. So please, I want to hear everything you have to say, but please be careful about what you say because it could hurt your case. At this time, I'm going to move to the first case. Agatha.
Honor, if I may, Judge, the jail has requested 2 cases be called out of turn.
Okay.
The first case is on page 4 of the docket. It is Kirkland Wilson.
Okay.
He's present at main jail.
Okay. Kirkland Wilson.
He's coming, Judge. Give us 1 moment.
I have reviewed your probable cause affidavit, and I do find probable cause. He has a violation of probation.
Judge, he's not present just yet. He's on the way.
Okay, I'm sorry.
I'm sorry.
And this is the case that's real old, right? No.
Commissioner Wilson's present, Judge.
Okay, good morning.
Good morning, sir.
I do find probable cause. You have a violation of probation. The bond was set at $5,000.
Right. Can I just input something, sir? Over a couple of years, I've been battling being forced to take medication that's messing with my ability to adapt through society. When I was in college, my mom sent me to a doctor, and he's prescribed me amphetamines, and then I ended up calling a freaking bomb threat
Okay,
on my
sir.
college and got
Sir.
expelled. Just hear me out, just 2 seconds.
I just do not want to incriminate any
Yeah,
incrimination.
I'm just sick and tired of all the disrespect, because I'm not a disrespectful person. I showed up yesterday. I was supposed to turn myself in last night, and they ended up sending me to court, playing with my mind. No different than they just sent me out this room to go to a cell, and then I come back. You guys, this county's indecisive. I'm a leader, man. Everywhere I go, I freaking know judges. I freaking know. It's just like, it's annoying, bro.
Okay. Thank you very much, and I hope you have a good day. Thank you. What was the other case?
The other case is Miss Lipton on page 7 of the court's docket.
Okay,
It's a Lorraine Lipton,
yes.
and she's also main jail.
Okay, we'll wait for her to come up. Okay, Miss Lipton, I see that you are charged with distributing, delivering cocaine. I do find probable cause. Counsel, is there anything you'd like to add?
Judge, at this point, I've had limited time to speak to Ms. Lipton, but at this point, she cannot afford bond is set. I ask the court to consider pretrial release. She does have a valid address that she can live at.
Miss Lipton, please,
She has lived here for 10 years, Your Honor.
in the same location?
No, I've been at that location for 7 years.
That location for 7 years, but she's been in Broward County for 10.
And do you have family and friends that live with you?
No, sir.
Okay, do you have family and friends that could help you post a bond?
No one has any money, sir.
Okay. And state, does she have any priors?
Yes, Your Honor, in
I can't hear him.
2002, out of Brevard County, she had a strong arm robbery. She was sentenced to 7-year state prison. Released in 2008, she has 12 prior felony convictions, 2 prior failures to appear.
Okay, the bond, do you have any recommendation?
Your Honor, based on her criminal history, nothing other than I'm not asking for any modification of the bond.
And the bond would be 4,500 or 2,500? 2,500.
Judge, just to point out, she was released in 2008 and has had no offenses since then. If the court would consider that as far as her priors go.
Okay, I will consider that. And did you have anything to add, Mr. Reedy?
No, Your Honor, I don't have anything to add. I think that there is probable cause. I would point out, as is pretty obvious, I guess, she's 68 years old. And anytime someone at that age, and I'm not that far away from that age myself, actually, but being incarcerated, someone's medical condition is always a cause of concern.
Okay. I'm gonna reduce the bond. I'll make it 1,500. And I wish you luck. Good luck, ma'am. Amy, no, not Amy. Let's go back to the beginning. Agatha Raymondville.
President at the major.
I have reviewed the charge of a touch and strike battery and the probable cause affidavit. I do find probable cause. State, does she have any priors?
Your Honor, I'm showing that she has. Does pretrial have anything?
Sentinel was arrested in 2000 for an aggravated battery and a burglary of a structure or conveyance. He received a decoy on that charge and the record.
Want permission for anything? I don't want to pre-trial. I don't want to pre-trial.
Okay, did you have a recommended bond?
I don't want
Your Honor, I'd be, based on her prior arrest and the allegations, requesting $2,000 bond, no victim contact.
And counsel, do you have any?
Judge, I can add that she's been in South Florida for 34 years. It's not a flight risk. I wanted to advise the court that the alleged victim has moved on. In the event he has not, she can live elsewhere. She does have an expense in terms of her father's passing. The funeral is being held tomorrow. The only person who possibly could bond her out might be her adult daughter. We'd ask for $1,000, Judge.
Okay, I will set bond at $1,000. I'm gonna do and she'll have no victim contact, direct or indirect with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or property from the home, have someone else go for you. Did you have something to offer?
I didn't know if you had said 1,000 with pretrial or just.
Yes, I do want
That's
pretrial.
what I thought I heard. Okay.
Thank you.
You're welcome. So that's standard pretrial supervision.
Judge, is that
Just-
standard pre-trial?
Yes, it is. Okay, Camilla Addison.
As soon as it posts, you can have a seat.
Okay, good morning, Miss Addison. You are charged with a touch or strike battery, domestic violence. I do find probable cause. State, any priors?
No priors, Your Honor. State would be recommending a $500 bond, no victim contact.
Okay, and counsel?
Well, based on this probable cause affidavit, Judge, it looks as though she pulled her mother's shirt. Certainly in the grand scheme of domestic violence cases, this would seem to be at the less violent end of the spectrum. I'd ask the court to consider an ROR, considering she has no prior record, and perhaps counsel can provide us with some information as to her ties to the community.
So she is a 20-year resident of South Florida. She's employed as an insurance agent. At this time, though, does not have any money in the bank. She does have a 7-year-old child that she takes care of and supports, and at this point has no one else to bond her out.
Okay, I am going to ROR her. I will put her on pretrial release. I also am going to require no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get clothing or any property from the home, have someone else go for you. And if there are any issues between you and the victim that are resolved, you can take care of that with the judge that you are set before. Good luck to you. Labath Carlo Joseph.
Those are the first two, Your Honor.
Good morning, sir. You are charged with a touch or strike battery, domestic violence.
And I'm on a pretrial.
I do find probable cause. State, are there any priors?
Your Honor, he was arrested in 2016 for domestic violence battery against the same alleged victim. That was dropped. I'm requesting a $5,000 bond and no victim contact, also noting that this allegedly occurred in front of one of their children.
How old are you?
Okay, counsel.
Just, Mr. Joseph can live with his father, which would be separate and apart from the alleged victim. He's a 17-year resident of Broward County, currently not working, but does provide support to the two children. He has less than $100 in the bank. It's possible his brother could bond him out, but the most he might be able to afford is $50. Maybe in combination, they could come up with $100 if Your Honor could consider a $1,000 bond.
Okay, I will consider a $1,000 bond. I will also require pretrial release, no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get any clothing from the property, from the home, have someone else go for you. Thank you very much. Good luck to you. Okay, Mike Ortiz. Good morning, sir. You have been charged with a violation of an injunction, protection, domestic violence. I do find probable cause. State, do you have any priors?
Your Honor, he's currently out on bond for battery against the same alleged victim. That's where the no contact order that led to this arrest stems from. He was advised at his first appearance not to have contact with the alleged victim. He's resisting without violence 2016, DUI property damage 2012. State is requesting a $3,500 bond, no victim contact.
Judge, this probable cause affidavit causes me some concern. Mr. Ortiz indicated that he had gone by the victim's residence because she called him and said she was hungry. He went to her house and left a salad for her by her door. And what strikes me most strongly about this affidavit is it states, "It should be noted both subjects have been in contact for the past several days, and both stated they were not aware of the no contact order issued by the court. They both live within a few houses of each other." So it appears, and I understand what Mr. Linder is saying, but it appears from what the information provided to the officer, was that neither of these individuals were aware of the no contact order. They were voluntarily having contact with each other, and she communicated to him to come by the house because she was hungry. So I think an ROR on this charge would be more appropriate.
Your Honor, that's why I mentioned he was advised by a judge in open court not to have contact. Whether she was aware of it or not, there was no order for her not to have contact with him. He was ordered by a judge not to have contact with her.
Okay, based on the priors, I'm gonna set bond at $3,500.
And I'm on a pretrial.
I'm also
Your
gonna
Honor, if I
play,
may be heard.
I'm sorry, what?
I just had some information I'd like the court to consider in setting bond lower than $3,500. I mean, he's currently living with his mother. He's an 8-year resident and his only employment is working home renovations. He doesn't currently have any money in the bank, possibly could afford $100, so I'm asking the court for a $1,000 bond, considering the probable cause arguments that were made as well.
Okay, I will take that into account. I'll set bond at $1,500. I'll put him on pretrial. And sir, there is to be no victim contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim, and if you need to get anything from the property, please have someone do it for you. And lastly, even if she calls you, you are not to have any contact with her. Do you understand?
Yes, sir.
And do not have any contact until you get permission from the court. It's the court that's ordering you not to have contact. Thank you. Good luck to you. Thank you. Okay, if we could move to Stephen Schust.
Present at the main jail.
Okay, Mr. Schust, you have been charged with battery, causing bodily harm, domestic violence. I do find probable cause. State, are there any priors?
I'm checking that right now, Your Honor. Unless Trace, if you. Honor, I see no criminal history. I'm going to be requesting a $3,500 bond. I'm also going to, obviously no victim contact. Your Honor, while it is a condition of the standard no contact order, I'm going to ask if the court could specifically order Mr. Schust today that he's not to be in possession of any firearms, weapons, ammunition until further order of the court, and that any firearms or weapons that he may still have access to after this hearing today, if he's released, be surrendered to his local law enforcement.
Okay, what was your recommendation for a bond?
$3,500, Your Honor.
I had all my guns removed already from the house.
Okay, and counsel, do you have any argument?
Yes, Judge, he has been in Broward County since 1979. He's a longtime resident. He can find a place to stay separate and apart from the victim. His only income is disability, so it's basically check to check, and he does have an 18-year-old and a 21-year-old in college that he tries to provide support for. Considering that there's no priors, Judge, and the fact that the only income is a disability check for the family, I'd ask the court to ROR or standard pretrial.
Okay, pretrial, is there any problem with that?
We take whoever the court orders.
Okay. Okay, I will set the bond at $1,000. I'll put him on a standard pretrial release. There will be no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. All firearms, munitions, and weapons need to be turned over to the police department or the sheriff's department. And if you need to get any clothing or anything from the property, have someone else go for you. Okay, thank
Yes,
you
sir.
very much.
Yes,
Good luck to
Thank you. Have a good day.
You too. Yes. Okay, the next person's Frankie Sannon.
I believe he's a medical loan judge.
Medical reset, yes.
Yes, okay, we'll do a medical reset.
You have an attorney?
Then we have
You want me to work on the defendant?
Will Jims June.
Good morning, Your Honor.
Good morning, how are you today?
I'm fine, and yourself?
I'm very good, thank you. You have a capias, outstanding capias with a no bond hold, and it's to be set in the division. And it's a no bond hold on the violation, injunction, domestic violence. Okay,
Okay.
thank you.
So I haven't caught it yet.
Not yet, it'll come up.
Your lawyer can help you get that. Philip McGee. Good morning, sir. You have a touch or strike battery, domestic violence. I do find probable cause. State, do you have priors?
Your Honor, in 2012 in Orange County, Mr. McGee was arrested for aggravated battery against a pregnant victim. The charge was dropped. Based on that prior arrest and level of violence alleged in this case, the state would be requesting a $2,500 bond, no victim contact.
Okay, counsel?
Mr. McGee does have a place to live away from the alleged victim. He has family, local, a sister, 3 children, ages 5 through 7 he supports. Currently, his sister is watching the children. He is employed at IKEA. Unfortunately, only has about $100 in the bank with no one to bond him out. I'd ask the court to consider a $1,000 bond.
Okay, I will consider a $1,000 bond. I will put him on pretrial release. No victim contact, direct or indirect with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get any property from home, have someone else go for you. Good luck to you, sir.
Thank you, Judge.
Thank you. Okay, we got Philip Tita.
President Ranger, Judge.
Excuse me? Good morning. Sir.
Good morning. Okay, is there any argument on this?
Excuse me?
Mr. Reedy,
Sorry, Judge.
any argument?
As far as probable cause is concerned, it appears as though there was a temporary protection order against him. I don't know that it was served. So, I mean, there may be an issue as far as that is concerned.
It stems from a no contact order from an open domestic violence battery case against the same alleged victim.
Okay, I am going to find probable cause after reviewing the probable cause affidavit. What's your priors?
Your Honor, he has the open battery against the same alleged victim. One moment. He was arrested in 2003 for a battery against the same alleged victim. That was dropped. Your Honor, based on the pending battery and that it appears he has violated his no contact order, and he was advised by Judge McHugh in open court not to have contact, I'd be requesting a $5,000 bond, no victim contact.
Counsel?
Judge, I'm sorry, I didn't hear what the state had asked
He had a few priors. He had one prior and then the open battery case that's pending that he violated the injunction protection order on, and he recommended a $5,000 bond.
She has been living in Broward County for 30 years, does not live with the alleged victim. At this point, his only income, he's a disabled veteran. The court would consider he's basically paycheck to paycheck in that regard. He has a friend who may be able to bond him out for $100. If Your Honor would set the bond accordingly.
Okay. Mr. Reedy, can we transfer this case to Veterans Court? Is that something that you'd
I
like
think
to
it has
do?
to go to division first.
I think
Okay.
maybe Judge McHugh might be able to do that,
Okay.
but I don't think
We'll
we
let her
can
do
do
it
that
then.
here.
If that's an issue. I am going to set the bond at $2,000. I'm also going to put him on pretrial release. There shall be no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, no ammunitions, no weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you have things at the home, which I know it's not your home, but if you do, have somebody else go pick them up for you.
Who's your client?
Your Honor, we just got a call from North Broward. They have no video.
Okay.
And they actually have the next person. And
Pretrial.
Okay.
Daniel
It's not out, but we handled it.
Thank you very much. Good luck to you. Okay, I see that, I can't see them. What's that?
We may need to make a call to the video people to find out what's going on.
So he should be at the main jail?
He is at main jail, Judge.
Okay.
I believed he was at North Broward. I hadn't had a time to speak to him.
It's okay, and he is charged with a touch or strike battery, domestic violence. I do find probable cause. State, do you have any recommendation
Uh,
or priors?
Your Honor, he had a battery in 2013, 2 counts of resisting with violence in 2011 with the violation of probation. Based on the totality of the allegations, Your Honor, I'm requesting a $2,500 bond, no victim contact.
State, defense, do you have any arguments?
Not at this time, Judge. Thank you.
Okay, I'm gonna set bond at $2,500. I'm gonna require pretrial release, no contact, direct or indirect with the victim. You can't go within 500 feet of the victim, no guns, ammunitions, no weapons of any kind. No calling, emailing, writing, texting, don't visit or even drive by the victim. And if you need to get anything from the home, please have someone else go for you. Thank you. Manuel Aguirre Renteria.
We were waiting for an interpreter for Mr. Renteria, Spanish.
We have one on the way, Judge.
Okay, there's one on the way,
Haven't
and,
seen Mr. Renteria.
and we will call him back up when we get one.
North Broward's back online, Judge.
Awesome. Okay, Murthia Themistol. Murthia Themistol. Okay, good morning. You have been charged with a touch or strike battery, and I do find probable cause. State, are there any priors?
Your Honor, Your Honor, I see no history. I am going to be requesting $1,000 bond. The $1,000 bond be kept in place and no victim contact, based on the level of violence alleged that Ms. Themistol and her co-defendant were kicking the victim on the ground and head and body while she was still on the ground.
Okay, and counsel, do you have any argument?
Judge, at this point, I'm not sure that Ms. Themistol can afford that bond. Her mom might be the only person to bond her out. I'm gonna try to give a call. I was unable to hear if there's a prior record, if the court.
There's
would
no
try to
prior
consider
record.
Pretrial. Can we ask for ROR, pretrial?
What I'm gonna do is I'm gonna set bond at $250. I will require no, and standard pretrial, no contact, direct or indirect with the victim. You can't go within 500 feet of the victim, no guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting, don't visit or even drive by the victim. And if you need to go to the home, please have someone go for you. Thank you very much. I'm sorry, what? $250. Okay, Sheila Diajusti. Okay, good morning. You are charged with touch or strike battery. I do find probable cause. State?
She has no record. I would just be requesting that the court set the same bond and release conditions as her co-defendant.
Okay. Any objection to that, counsel?
Not at this time, Judge. I'm gonna try to give her mom a call.
Okay, that would be the $250 in pretrial.
Yeah, no.
I'll set bond at $250. Pretrial release, no contact, direct or indirect with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get clothing or property from the home, have someone else go for you. Moving on to Regina Hawkins.
And
State, I see you
well,
stood
I'm just
up.
waiting for him. Yeah, I'm just.
Leave North Broward, Your Honor.
Okay, I don't see her at,
Deputy at North, do you have Regina Hawkins?
Medical reset.
Medical reset.
okay. I am not going to find probable cause on this, and
Well, Your Honor,
At
that's
this
what I was.
time?
That's what I was going to address. That I believe there's probable cause for burglary of a conveyance, it's just not armed. It appears.
I would agree with that, Judge, but I don't see anything about an armed incident here at all.
I agree, so
It's still a medical reset.
it's
so-
a medical reset, so if you want to perfect that, you can, or
Well,
change something, you can.
Yeah, I mean, I'm probably just going to ask the judge tomorrow, just to, if she's assuming she's here, just to find probable cause for the burglary conveyance.
And I would ask you to reset it for tomorrow as well, Judge.
I'm
in
doing
case she's
that.
feeling better.
It's already done. Great convincing argument. Amy Tedder. Amy Tedder? I'm sorry, I couldn't hear where she.
I believe it's North Broward.
Okay, Miss Tedder, you have been charged with a petty theft and resisting officer obstruction with violence. I do find probable cause. State, did you have any priors?
She has, out of the state of Ohio from 2004, resisting arrest. That's all I see here.
Okay, and counsel, do you have any argument? It's Amy Tedder.
Judge, I'm sorry. Yes, I spoke with Miss Tedder, Your Honor. She actually has been down here trying to get into treatment. I'd asked the court to recall her case. I put a call into the rehab facility where she was living. She's indicated to me she still has a place to stay there. I called over there earlier, and I'm waiting for a call back from one of the counselors to confirm that she can stay. If that is confirmed, I would be asking the court to release her on pretrial release with a condition that she goes back to the program called Destination Hope, which is on Powerline Road. So if you could give me a little bit more time to work on that and see if we can arrange something for her, I'd appreciate it, unless the state has a vehement objection to something like that.
Well, if she can go back in, then I would be asking for pretrial GPS, because it appears, one, that she might have walked away from that rehab. Two, she doesn't really have ties to the community. But I guess we should wait to hear if they'll take her back or not.
Okay, so do you want me to set it in the afternoon or later this morning?
That might be a good idea, Judge. Maybe set it for this afternoon. That'll give me the lunch hour to work on it.
Okay, sounds like a plan.
Okay.
We will reset her for this afternoon.
All right, Amy, we'll see you this afternoon, okay?
Good luck to you, ma'am.
Thank you.
All right, Nicole Martinez.
She's a medical reset, Your Honor.
Okay. Good morning. Did you want me to call one of your cases?
Well, I do, but eventually Ms. Martinez also has a municipal ordinance as part of her.
Okay, it's all Capias's. And she had a medical reset, so I'm inclined not to change anything.
Okay, she's medically reset on
Yeah.
page, okay. I'm just gonna give you the order, Your Honor.
Okay, thank you. Timmy Lee Brown? Yeah, these are counts 3 and 4 were Capias's. They're from 1994.
So
And he is set for 6/11/18
He's
at 10 a.m.
He's at the main jail, Your Honor. He's on page 10 of the docket. What I noticed is that he's on pretrial release. Apparently he had some felonies and counts 1 and 2, he's on pretrial release. Timmy Brown?
Just waiting on this guy.
Yes, Timmy Brown.
I don't see him at the podium.
Counsel, is Mr. Brown there? Here he
Here he
comes.
comes.
He's present at the main jail.
Good morning, Your Honor.
Morning, how you doing today?
Okay.
Good to see.
So Judge, what I was saying is that apparently he had counts 1 and 2 or count 2, I think. It doesn't show up, but he's on pretrial release on felonies, Judge. And I was going to ask if you would release him on his own recognizance in his municipal court police cases, so I can file an appropriate motion to dismiss based on statute of limitations.
Okay. State, is he in on the felony?
He coming. No, I didn't know we were going on.
On the felony, he's gonna be released on a pretrial? Okay. I am gonna ROR him on both counts, being that they're 1994 cases, that he is in the jurisdiction of the court at this point in time, and that he has a legitimate motion to file. Thank you.
Thank you, Judge.
Okay,
Thank this being said.
I said that you are being ROR'd on these cases.
You're being released on your own recognizance, Mr. Brown.
Right, that's what I'm trying to hear, but there's so much going on in the courtroom, Your Honor, is all.
Okay,
Thank
if
you.
everybody could kind of be quiet so that all of you can hear each other when you're in court, in front of the court. Okay, thank you, sir. Good luck to you.
Judge,
Thank you.
3 other cases left.
Yes, which one?
Judge, there's Joseph Curtis. He's on page 11. He's in the main jail.
Okay, Joseph Curtis. He is also charged with violating a municipal ordinance. And Mr. McLawrence, what would you like to tell me?
Judge, we would like to resolve this matter. The only issue is that Mr. Curtis has a case that's not on the docket, that's pending. And his situation is he's homeless, he doesn't receive notice, so we go through this cycle of warrants being issued for his failure to appear, and so on and so forth. So if we could, I would like to resolve both matters. If that means we have to reset it for the afternoon, I don't know. But
Well,
like to see
I
the
only
case.
have this one case. I don't have any documents on the other case.
Judge, I represent him on the other case. I have the case number. I could provide it to you, or I could bring you the documents this afternoon if you like.
Okay, let's reset him for this afternoon.
I'll bring it back.
Okay, Mr. Curtis, we're gonna bring you back in the afternoon and take care of both of your cases.
Thank
Okay?
you, Your Honor.
All right. And what else?
Judge, on page 11, there's Joseph Serrato. He's in the main jail as well.
Okay, Mr. Joseph Serrato, you are charged with violating a municipal ordinance as well. I do find probable cause. Mr. McLawrence?
Judge, I didn't get an opportunity to speak to Mr. Serrato. Certainly, if he would like to resolve this, Judge, I think it's a case that we could resolve in magistrate's court.
Sir,
Please don't talk about the case, Mr. Serrato. Just hold on a second. Let the judge speak for a second.
And what is it that you wanted to resolve the case as?
Judge, is it time served?
Sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
You could speak, Mr. Serrato.
You have to say it out loud.
yes,
Okay, you can put your hand down if you want to. Do you understand English?
yes,
And do you wish to enter a plea of no contest?
yes. A plea contest?
If you plead no
Plea no contest?
if you plead no contest, you're not admitting or denying the charges, but you're telling me you'd like to resolve the matter today, and I'll sentence you to an adjudication court cause.
Yeah, I want to resolve the case today.
Okay, so do you want to plead no contest?
Yes.
Sir, behind him, please be quiet so he can answer himself.
Pleading to no contest, you clear today?
Okay, and do you have any questions for your lawyer?
No, I don't have a lawyer, but.
Yes, you
I'm
do.
asking
You have
if I
Mr.
plead-
McLawrence representing you right here.
If I plead no contest, sir, if I plead no contest, explain to me once more.
If you plead no contest, you're not admitting or denying the charges, but you will be telling the court that you don't contest the matter. I'll treat you as if you pled guilty, and I'll sentence you today to an adjudication of guilt and court costs. I'll give you a year to
Okay,
pay
no,
the
I
court
plead-
costs.
I'm pleading no contest, Your Honor. My lawyer,
Okay, I'll sentence you to an adjudication court cost. Good luck to you, sir.
Thank you, Judge.
Our Spanish interpreter is here,
I
Judge.
see. Did you have another case?
That's just the last one, Your Honor. There's a Matthew Furry. He's on page 11. He's also in the main jail. It says no paperwork.
He bonded, I guess I heard.
Seems like he bonded, Judge.
Okay, all right, thank you.
Okay, good luck to you.
Page 11.
Is it not Henry Elowett, you didn't say?
No, Matthew Furry.
Okay. All right, I think that takes care of your case. Going back to Manuel Aguirre Renteria. That is the Spanish interpreter case. We have an interpreter here. If the interpreter could please raise the right hand. Do you swear to translate from English to Spanish and Spanish to English?
Yes, I do, Your Honor. Theodore Leal, L-E-A-L, for the record.
Okay, thank you. Sir, I see that you have been charged with a violation of injunction protection, domestic violence, and I do find probable cause.
Señor, veo que lo acusan aquí de una violación a la orden de alejamiento, orden de protección por violencia doméstica y determinado que hay indicios.
State, do you have any priors?
Yes, Judge.
Antecedentes, sí, antecedentes.
Your Honor, I'm going to be requesting a $10,000 bond,
Okay, $10,000 de fianza, señor juez.
pretrial release with a GPS monitor, level 2,
En libertad provisional, pero con el monitor GPS, la tobillera,
and no victim contact.
y prohibido el contacto con la víctima.
Mr. Renteria is currently on probation
Actualmente el señor Rentería está bajo régimen de prueba
for domestic violence battery against the same alleged victim that occurred last year.
por agresión de violencia intrafamiliar con la misma víctima que ocurrió el año pasado.
Judge McHugh placed him on a year's probation March 8th of this year.
Marzo 8 de este año la juez McHugh lo puso bajo régimen de prueba.
He was also arrested in 2016 for battery against the same alleged victim.
Y en el 2016 también fue arrestado por agresión física en contra de la misma víctima, supuestamente,
The charge was dropped.
y ese cargo fue retirado.
I believe this bond and release conditions are necessary to ensure that Mr. Renteria stays away from the alleged victim.
Y yo pienso que esta fianza y estas condiciones son necesarias para que el señor Rentería se mantenga alejado de esta presunta víctima.
Okay, and counsel, do you have any argument?
Argumentos del abogado de la
So So
defensa.
she is a 17-year resident of South Florida, currently employed in the roofing business, makes approximately $500 a week with one child to support, and he does not have any money in the bank. And that's the most I could communicate with at this point, so I think that the bond stays for is tantamount to no bond, as he doesn't have any money in the bank and was making $800 a week, but he is incarcerated.
El señor Rentería tiene 17 años ya de residencia en esta región. Él está actualmente empleado. Él trabaja en el negocio de techadores, como techador. Gana aproximadamente $500 por semana. Él no tiene ningún dinero en el banco, no tiene condiciones económicas como para poder pagar esa fianza.
Sir, you have lived here a long time, so my question is, do you have any family or friends that can help you?
Señor, usted ha vivido aquí por un largo tiempo. Mi pregunta es, ¿tiene usted familiares o amigos que puedan ayudarlo?
Tengo un hermano, pero es igual.
Answer that, Rob.
No, tengo un hermano, pero es igual que yo, es un trabajador, no creo que tenga dinero ahorita mismo.
I have a brother, but he's a worker like me. I don't think that he's going to have any money right now.
Do you own or rent a home?
Señor, ¿usted es propietario o renta una vivienda?
Renta vivienda.
I rent a home.
All right.
Bien.
I am going to set bond at $5,000.
Una fianza de $5,000.
Based on the statements by the state.
Basado en la declaración de
I'm also going to place him on pretrial 2 with a GPS monitor.
Y también lo voy a colocar en libertad provisional, pero colocándole la tobillera del GPS.
And based on the fact that he violated probation.
Basado
I'm
en el
going
hecho
to also do no contact, direct or indirect, with the victim.
No puede contacto ni
You
directo
can't
ni
go
indirecto con la
within
víctima.
500 feet of the victim, no guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim, and if you have anything in the home, please have someone else go get it for you.
Se está alejado a 500 pies de distancia. Se le prohíbe cualquier tipo de contacto, sea por teléfono, sea por escrito, sea por mensaje de texto. Ningún tipo de visita, ni siquiera puede pasarle conduciendo, manejando por la casa de la víctima. Y si necesita sacar alguna pertenencia, tiene que ser otra persona que extraiga la pertenencia de su casa.
Okay, thank you and good luck, sir.
Gracias y buena suerte, señor.
Jose Hernandez?
Judge, I have a correction for Mr. Hernandez.
Okay.
On reference count 2, this is a VOP. However, count 1 and 3, he has already posted bond.
Okay.
But count 2 is a VOP, not a key.
Okay, sir, the count 2 is a violation of probation, and that's to be set within the court that you have been assigned.
El cargo número 2 es una violación a su régimen de prueba. Eso se va a dejar para la corte.
I'm sorry, we didn't need an interpreter for Mr.
I was going to
Hernandez.
ask you to wait just 1 second. Okay, counsel, State, did you have anything to offer?
No, I'm just asking that, obviously, the bond that
Okay.
Judge Solomon said.
Okay, and counsel for the defendant? I do find probable
Not this
cause.
time, Judge.
Okay, I find probable cause and we'll leave everything the way it is. Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesita el intérprete de español?
Okay, then, thank you very much.
You're welcome.
Have a wonderful day. Okay, we have Monty Ray Abel.
North Broward, Judge.
Okay, sir, how are you today?
Pretty good.
Great. I see you've been charged with possession of cannabis. State, did you have a recommendation?
Your Honor, unfortunately, I really can't make an offer at this time because any offer would involve jail or probation, and the reason being, I understand it's a possession of cannabis. I've actually spoke to Sergeant Baker, who authored the probable cause affidavit, and Mr. Abel has really been a nuisance in the area. He was just here last week. He was arrested last Monday for loitering or prowling, resisting without violence, cannabis, and drug paraphernalia, and he got time served last week. He was released on Tuesday, and
Okay, Mr. Reedy?
Mr. Abel indicated to me that he's been living in the same location for the last 2 years. Has his own business, which is Abel Carpets. He would like to resolve the case today. He does not have any money in the bank. He does not have any money saved. He cannot make a $100 bond.
You said he owns a business?
Yeah, he does, but I don't think he makes a lot of money at it.
Well, you
Uh,
have
and
to
he-
have some money to run a business.
Well, he indicated to me he just got back from vacation and kind of spent all of his money while he was on vacation. So he doesn't seem to be in a position to be able to bond himself out. I understand. I know, the probable cause affidavit certainly indicates more than what might be considered a possession of marijuana charge, but essentially that is what we're talking about, is one marijuana cigarette. I'd ask the court to consider withheld adjudication and court costs.
State, did you have a recommendation to resolve the case?
Your Honor, state's offered being adjudication 10 days, and I just want the court to be aware, based on the representations that have been made, the allegations of his case last week, and I'm only bringing this up for why I'm offering 10 days. In that case, he was apparently looking into car windows.
Okay, you know what, based on the priors and,
If I might just add one thing, Judge.
I am not gonna resolve the case.
Okay, then I would ask you to ROR, Mr. Abel. I'm looking at the risk assessment that was prepared by pretrial release, and it indicates that Mr. Abel is a low risk of either reoffending or failing to return to court.
Based on the priors and the fact that he was here a week, just recently, I don't know that I agree with that risk assessment. He's committed another crime while he was out on one. So I also would like to give him the opportunity to get into drug court if he would like to. And So I am going to keep the bond at $100, and he can make that decision in court, in the court he goes to. Okay, thank
Judge, I'll
you.
make that call for you, Mr. Abel.
And I do find probable cause. Thank you. Larry J. Nystrom.
No problem, Your Honor.
Okay,
Mr. Nystrom would like to resolve this case today if possible, Judge.
okay.
Yes, sir.
I do find probable cause. State, does he have any priors?
Your Honor, I just saw prior possession of cannabis. The state's offer to be a withhold, court cost judicial notice of time served, just no return to the Dania Beach Casino.
Okay,
Is that what you'd like to do, Mr. Nystrom? Not have a conviction on
sir.
your record and get out of jail, have to pay court costs? And
Yes,
stay
sir.
away, and stay away from that casino?
Yes, sir.
okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
The whole truth and nothing but the truth.
Okay,
So, me God.
you don't have to repeat everything I say, you just answer the question yes or no. You can put your hand
Yes.
down. Do you understand English?
Yes, I do.
How far did you go in school?
GED.
Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of guilty, not guilty, or no contest?
Guilty.
Okay, and do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
And do you have any questions for your attorney before we conclude?
Not really.
Do you, okay, I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to a withhold court cost, no return to the Dania Casino.
Okay, sir.
Good luck to you.
Thank you.
All right. Leonardo Jose Sequani.
Sequani bonded, Your Honor.
Okay. Kevin Lavetta Jackson.
Medical reset.
Medical reset, okay. Eddie Laderick Rancher. Good morning. You have been charged with resisting an officer and trespassing. I do find probable cause. State, do you have any priors?
Yes, Your Honor. Mr. Rancher's last arrest was May 27th. That was for a trespass in West Park. Prior to that, May 16th, for a trespass in Pembroke Park. April 8th, trespass. Same location as this arrest. Your Honor, if Mr. Rancher wants to resolve the case, the state's offer would be 10 days, adjudication 10 days county jail.
Okay, state, Mr. or counsel, do you have any?
Judge, I know that Mr. Rancher would like to resolve. Currently, does not have a residence maintained. He lives on and off with his mom. Getting mail would be difficult. He would like to resolve, but we'd ask for time, sir. He's been in custody for 4 days.
Okay, I will do an adjudication, court costs, time served, if you'd like to resolve it. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you understand English?
Yes, sir.
How far did you go in school?
10th grade, sir.
Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
Do you have any questions for your attorney?
No, sir.
Do you understand if you're not a citizen, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
Okay, the court finds you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea based on the document, and I will find a factual basis and sentence you to an adjudication court costs credit for 4 days' time served.
And Your Honor, I'm just asking that the condition of the plea be no return to this maritime.
And there will
jurisdiction.
be no return to the location.
Yes, sir.
Okay, good luck to you. Dane Orlando Josephs?
No problem, Your Honor.
Okay, sir. You have been charged with a petty theft second degree, a petty theft second degree, and another petty theft second degree. State, any priors?
Your Honor.
I do find probable cause.
There are, Your Honor, and the state's offer to resolve all three thefts in this case would be adjudication, 25 days county jail. He just got out of custody May 29th after resolving a felony theft, and felony theft to 30 days, a misdemeanor theft in front of Judge Lerner Wren. That was, the allegation in that case was he stole alcohol at the same Publix as the three in this case. Felony theft 2017, felony theft 2016, felony theft 2015, felony theft 2015, felony theft 2014, two more felony thefts in 2014, two more in 2013, another petty theft in 2013, theft 2012, another two more thefts in 2012.
Okay, Mr. Reedy?
Well, Mr. Joseph did indicate to me, Judge, he would like to resolve the cases. I don't know that he wants to resolve them for 25 days in the Broward County Jail. I understand what the state is saying about his prior criminal history. There are other issues involved as well with Mr. Joseph's. I was wondering if the court would consider something much less than 25 days.
I will not.
All right, Mr. Josephs, do you understand the offer that's being extended to you?
Yes, Your Honor.
Do you want to take a plea to 25 days in the Broward County Jail, or do you want to maintain your innocence?
I take that plea.
All right.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Do you understand English?
Yes, Your Honor.
How far did you go in school?
I went 10th grade.
Do you understand the charges filed against you?
Yes, Your Honor.
Do you wish to enter a plea of guilty, not guilty, or no contest?
Guilty.
Okay, do you have any questions for your attorney before we continue?
Judge, I'm trying to go to Atlanta because I'm homeless here. That's why I'm doing so much corrupt stuff. I really want to go back to Atlanta where I'm from.
When you get released, you can go wherever you'd like, as long as it's a legal thing. Okay?
Yes, Your Honor.
Okay, you can't trespass, but you can, if you want to go to Atlanta, you can go to Atlanta.
Yes, Your Honor.
Are you under the influence, wait. Are you under the influence of drugs, alcohol, any other substance right now?
No, Your Honor.
And do you suffer from any mental illness?
No, Your Honor.
Has anyone threatened you, coerced you, or promised you anything to get you to make the plea?
No, Your Honor.
And do you understand as described, this plea could serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, Your Honor.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, Your Honor.
The court finds you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. Based on the documents in the file, I find a factual basis for the plea, and I'll sentence you to an adjudication court cost, 25 days credit for time served. Good luck to you.
Thank you, Your Honor.
Antonio Derrico.
He's in contact, Judge.
Your Honor, can I say something before you make a probable cause decision, sir? Good morning, by the way. This is Derrico. Good morning.
Good morning. Wait just 1 second. Your attorney might want to say something on your behalf.
Okay.
And what is this?
The original probable cause affidavit that formed the basis of the
Judge, can we recall this briefly? Let me speak to Mr. Derrico before he says anything.
Okay, that would be fine. Mr. Derrico, just wait 1 minute. Your attorney would like to talk to you for a second.
Yes, sir.
Okay, Alex Hughes.
All Ryan.
All right, Your Honor.
Okay, Mr. Hughes, how are you today?
Yes, sir. I'm doing all right, sir.
Okay, it looks like you have a felony capias, which is holding you, and you have a date coming up on June 11th at 8:45 a.m. Okay?
Your Honor, this is an ad charge. He's entitled to have a bond set today. The top count was an aggravated battery that was filed as charges. He had a $15,000 bond on that. I'm going to be requesting that the court set the bond on count 2 at $5,000.
Okay, counsel, did you have any argument?
Not at this time, Judge.
Okay, then I'll set bond at $5,000. Good luck to you. Okay, Henry Elowett. Okay, Mr. Elowett.
How you doing, Your Honor?
I'm doing fine, thank you for asking. You have been charged with count 3, a burglary of an unoccupied conveyance, and count 4, a petty theft of the 2nd degree. I do find probable cause. State, did you have any priors?
Your Honor, these are ad charges. He came before Judge Levy yesterday morning on charges of strong arm robbery and illegal use of a credit card. Bond was set on those 2 counts at $5,000 on count 1, $1,000 on count 2. I'm going to be requesting that bond be set on the burglary conveyance at $2,500.
Okay, and counsel, do you have any objection?
I'm sorry?
I think 2 or 3 days.
The count 3, the bond recommendation by the state was $2,500.
Judge, at this point, he's an 18-year resident. He's not a flight risk. He's not working. He's going to school at Wooden Rogers and has 1 newborn child he supports. Clearly, at this point, he's been in custody for a few days on the current $5,000 and $1,000 bond that he cannot afford. I'd ask the court to ROR this count.
Okay, state, does he have any priors?
He had a very lengthy juvenile record. That's why Judge Levy set the bond at $5,000 on the strong arm robbery. That was also against the juvenile, Your Honor.
Okay. Well, I do find probable cause. I'll set bond at $1,000.
Your Honor, we just request no victim contact.
And no victim contact, absolutely. That is indirect or direct, so you can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Good luck to you, sir. Okay, let's move on to Christian Sanchez Bergola. I've reviewed the probable cause affidavit, and I do find probable cause. State.
Your Honor, I'm going to be requesting a $10,000 bond. Mr. Sanchez Bergola has no criminal history. My concern is the allegations and really the other motorists on the road that could have been put in harm's way by his actions. I'm going to be requesting no victim contact and an order that he not be in possession of any firearms, weapons, or ammunition until further order of the court.
Okay, I neglected to say, this is a missile, you're charged with missile into dwelling, vehicle, building, or aircraft. I did find probable cause. And counsel, do you have any argument?
I wanted to inquire, I didn't hear if there were any priors.
He said
that
no
the state was-
priors. His recommendation on the bond was based on the allegations in the probable cause affidavit.
And that was what amount? I'm sorry, Judge?
$10,000.
Judge, he's been in Broward County since 2002. He has a wife whom he lives with, his mother, 2 children, ages 4 and 2. Currently, he is unemployed. The only one who would be able to bond him out would be his wife, but the most, given the limited income, would be $150. I'd ask for a $1,000 bond.
Okay, but based on the allegations, shooting a firearm at a vehicle, I am going to set bond at $15,000. I am also going to require pretrial release, and I am also going to require no victim contact, direct or indirect, with the victim. You can't go within 500 feet of the victim, no guns, no ammunitions, no weapons of any kind, no calling, emailing, writing, texting, don't visit or even drive by the victim. And,
Your Honor, what level of pretrial supervision?
yeah, I'll do standard pretrial.
Okay, thank you.
Thank you.
We can recall Mr. Derrico if you wish, Judge. He's in Conte.
Okay, getting back to Mr. Antonio Vashun Derrico in Conti. He's in on a capias. He has a hearing set June 11th, 2018,
Yes, Your Honor. And speaking with Mr. Derrico,
and I do find probable cause.
an information in this case has been filed. And count 4 is criminal mischief, not throwing a missile into a public or private building as is reflected on the docket. Counts 2 and 3 are aggravated assault. I believe probable cause has already been found on the first 3 counts. But I think the docket here is wrong. This should be a misdemeanor that Mr. Derrico is before the court on today, unless Mr. Linder can educate us as to that.
I certainly can. Your Honor, what happened was when he was first arrested, he was arrested for 2 counts of aggravated assault, 1 count of criminal mischief. We charged the shooting at or throwing a deadly missile at us before the court today.
Okay, but it's not listed as count 4 in the information.
No, it's count 1 of the information. Remember, you're going by the charge that's on the booking sheet or in the docket, which is the charge that he's being held on by the jail. They're not always the same. The count of the information.
So what are you looking for?
Your Honor, he's being held on $5,000 bond, each on the 2 aggravated assaults. I'm asking for the same $5,000 bond on this count.
How do you feel, Mr. Derrico? If you want to say something, that's fine, but I must caution you that everything you say is being recorded. So please do not discuss the facts of the case at all. You can discuss with us how much money you might be able to come up with to post your bond.
And, Your Honor, noting that 1, it is a 2nd-degree felony, and also, just to advise the court, Mr. Derrico's criminal history, a disorderly conduct, May 2nd of this year, felony theft last year, felony theft 2016, 2014, 2012, 2011. He's gone to prison for possession of cocaine with intent in 09, a battery, he had a battery in 09, failure to register as a career offender in 09, prior battery as a law enforcement officer he's gone to prison on.
Okay,
How much can you afford to post for bond, Mr. Derrico?
Okay, listen, I still want to say what I want to say to you on
Mr. Derrico, again, I will caution you, do not discuss the facts of the case. Do not put yourself at the scene. But if you want to go and talk, go ahead.
all right, okay.
he's your attorney, and he's trying to advise you the best he can, sir. If you, at this point in time, based on his prior history, I do find him to be a danger to the community, and I'll set bond at $5,000.
All right, Mr. Derrico, you're going to court on June 11th, and maybe you can get a few more of these issues straightened out at that time.
You will have an attorney there in the courtroom who you could talk to directly.
He does have a public defender already appointed on his other
What does
charges.
probable cause mean, sir? I'm just want to clarify that what that means.
That's the burden that the police officer has to have and that the state had to have to file the information against you. Okay, when you go to trial, they have to prove the case beyond a reasonable doubt, which is a much higher standard. All right?
The allegation is that you injured the property of the VIP market, which the glass door, by damaging it, but the damage was less than $1,000. That's the criminal mischief.
And, sir, you will also have an opportunity to ask all these questions to your attorney, and I'm sure they will visit you in the jail as well. Okay? Good luck to you. Timothy Kylo.
He's approaching, Judge.
Great. Okay, Mr. Kylo, you were charged with a petty theft and a trespass. I do find probable cause. State, did you have any priors?
The defendant is currently being supervised by pretrial service.
Okay, so he violated while he was on pretrial?
Yes, Your Honor.
Okay.
Case number 185848 CF10A for a felony petty theft. Based on this court's finding of probable cause, we're gonna ask that his pretrial status be revoked at this time.
Okay. State?
Yeah, Your Honor, and I'm just gonna advise, request that the bond be kept in place. He was just arrested last week on a capias for trespass. Then he was arrested May 17th on the case that he's on pretrial for. April 3rd for another capias on a trespass. March 5th, 2 capiases on open containers. And then January for a trespass. And it looks like 6 other capiases on trespasses. He's been through this division often, Your Honor.
Okay, counsel?
What I can advise the court is that he is a 27-year resident of Broward County, only employed in lawn service and odd jobs, landscaping. Doesn't have any money in the bank, stays with a friend sometimes, but is often homeless. I know the state mentioned capias. I think that the issue there is without a residence for notice. That's why those continue to be a problem. The bond is set. I don't believe he's going to be able to afford. If Your Honor could, if he was calling in on pretrial, on the standard pretrial, if we could maintain that for both cases. I know they're asking to revoke, but at this point, he cannot afford the $750.
Okay. On the revocation, what's the state asking for the bond to be?
Your Honor, I'd ask that the court leave a no bond and let his assigned judge decide how best to proceed.
Okay, I will do that. And on this case, the trespass, I'm gonna do an ROR. The petty theft has a $750 bond.
Thank you.
Okay, good luck to you, sir. Hakeem Newman. Okay, sir, you have been charged with a burglary, unoccupied conveyance unarmed. I do find probable cause. State, does he have any priors?
He does, Your Honor.
No, I didn't touch Owning properties? I'm sorry, Judge, I couldn't hear what the state was
I
mentioning.
couldn't hear anything either.
Okay.
He handed me a document,
I'm sorry.
which he handed your colleague as well, so.
Your Honor, I'm
It's the
providing
juvenile record.
the court with this juvenile record, so I don't want to put out the details over the air.
Okay,
Your Honor, I'm requesting a $5,000 bond. As you can see, based on his juvenile history, there are like offenses. It appears that some may even be pending. These all pickup orders have had to be issued in the past for after he's absconded as well.
okay, he also has a capias with a no bond hold.
Is that for the juvenile?
Oh, no, Your Honor, it's a hold for magistrate to have a bond set.
Okay. I'm just reading what I have here.
Understood.
Counsel, did you have an
With
argument?
regard to this case, yes, Your Honor. I've been advised that he self-surrendered on this. He's been a resident of Broward County 11 years. Currently, he was residing at Covenant House seeking treatment. He's been there for 1 month. So I understand there was a bit of a mention of a juvenile record. However, he's trying to clean himself up. He's been at the Covenant House, was advised of this charge, and I believe surrendered to come to court. I'd ask the court to consider releasing him back to Covenant House. It's my understanding that they will take him. I think this case is a previous habeas that was outstanding.
Your Honor, I'm showing the place of arrest is 5510 Southwest 36th Street, West Park.
He went to a friend's house and surrendered himself.
No, just to let the court, I mean, my understanding usually when one surrenders themselves, they go to the police let them know they're to be taken into the capias. This is, I'm looking at it in Google imagery, this is clearly not, it's not a police station.
But my understanding is he called the police to advise he had a capias to be picked up. I'm not sure, I didn't hear what the state's argument was. But
Okay, and what was your recommendation?
5,000.
Okay. And does your client have a job?
No, Judge, he was not working. He was trying to seek treatment at the Covenant House.
Okay. I will set bond at $2,500 and put him on pretrial release. I would like him to go back to the Covenant House, and that would be it. No vic, no, yeah, standard.
Judge, I'm just mentioning to the court, he has no one to bond him out. He's on his own. That's why he's living at the Covenant House. If the court would reconsider, at this point, he would not even be able to have anyone to pay $250 to bond him out.
Okay, thank you for that. I'm gonna stick to what my order was. Thank you very much. Scott Lloyd Mayberry. Sir, you've been charged with a petty theft and a trespassing. I find probable cause. Do you have a recommended offer in this case?
It's a felony, a third or subsequent.
Oh, okay.
Your Honor, I'm gonna be requesting that the bond be kept in place. One, this is Mr. Mayberry's 15th arrest in the last 2 years. And also noting, according to the store's owner, that he has gone into this store stealing a bottle of wine every day for the last 2 weeks.
Yeah, I noticed that.
Yeah.
Okay.
Alcoholic.
Counselor?
Judge, at this point, Your Honor, he is a 45-year resident of Broward County. His only employment is through the labor pool. He does not have anyone to bond him out, no money in the bank. I believe he could call in if Your Honor could place him on standard pretrial. He would also like to get into a program for assistance.
Okay, how about,
diagnosis program.
if you would like, I'm gonna keep the bond at $750 and we could put him in SAP.
We could. That would be fine, Your Honor.
Mitigated.
Yeah.
Yeah, probably.
Well, it depends on how, if you just want him to be in set while he's there,
Yeah.
then he can go voluntarily. I mean, if he wants to go, he can go.
Well, I wanna order it.
Okay, then we need to.
Yes. And it will be $750 bond. The other count will be an ROR. All right. Ulysses Cunningham.
In North Broward, Your Honor.
Okay. Mr. Cunningham, you have been charged with a burglary, unoccupied dwelling, unarmed. I do find probable cause. State, does he have any priors?
One moment, Your Honor. He does 2010 grand theft, 7 years state prison as a habitual offender. 2010 burglary of a dwelling, grand theft from curtilage or dwelling, 7 years state prison as a habitual offender. 09 resisting without violence, 2 counts. His other priors go in the late 90s, burglary, tools, delivery of cocaine. Your Honor, I'm showing he was released from state prison November 4th of last year. Based on his criminal history and the allegations, and this involves someone's home, requesting a $20,000 bond and no return to the property, no victim contact.
Okay, Counselor?
Based on my conversations with Mr. Cunningham, Your Honor, he's not going to be able to make any monetary bond at all. He has been a resident of South Florida for all of his life. He does not have a stable home at this point. He also has a medical condition that will make it impossible for him really to work at this point. It also may have made it impossible for him to have committed this crime, but based on the statements he allegedly made, I understand the court finding probable cause. Judge, the only thing I can ask you for is pretrial release, because he's not going to be able to make any kind of monetary bond. Did you want to say something, Mr. Cunningham, and not about the facts of the case?
I'm not hearing him.
No, Deputy, can you help us out over there?
He might be too far from the microphone. If the deputy could push him closer, maybe?
You can,
There it is, okay.
all right, Mr. Cunningham, everything you say is being taken down and recorded and will be used against you later. So please do not discuss the facts of the case. Do not even put yourself at the scene. All right? So if there's something else that you want to talk about, that's fine.
I suffer from a stroke on the whole left side of the body. I taxi somebody give me a taxi and end up here. I don't have no use of my whole left side of my body right now. And I taxi somebody, that's what I do to survive. I have been driving people around. I lost my home, I lost my job due to the stroke. And I have been driving people around as taxis. I taxi somebody else and I end up here.
Okay, thank you very much. I didn't mean to interrupt you. If you want to keep
I don't
talking.
understand what's going on because, yeah, I have priors. I've lost everything that I can. And y'all see that I got all this bond and stuff. And I have a truck. That's all I have left. My truck is all I have left. And I've been trying to scrap with that. And people have been using me for taxes. I've been sleeping in my truck. I did not commit a crime. I did not commit a crime.
Okay. Today is not about your guilt or innocence. It's about whether there's probable cause. I do find probable cause. You also have a great many priors.
But I'm unable to commit this crime. I'm unable to even commit a crime.
You still have all your constitutional rights so that you can have your defense in court. This is just a bond hearing. Based on the priors, I'm going to set bond at $5,000.
I would just ask for an order no return to the.
And a no return to the location.
Thank you.
Thank you. Good luck to you, and you will have an attorney to speak to, public defender, with your case, and you can go over that whole argument with them. Okay, good luck to you. Heli Cadeaux, Cadeaux.
Your Honor, if I could be heard before the court makes a probable cause determination.
Okay.
Thank you.
Counsel?
You can find the public defender, Your Honor.
Counsel?
Thank you, Your Honor. Your Honor, upon review of the probable cause affidavit, I do not believe there's probable cause for the custodial element of the offense. I do believe that there is probable cause for the assault against a victim over 12 under 18. So I would ask the court to find probable cause for that count, for that offense.
What about 2 and 3?
I believe there's probable cause for 2 and 3. I'm just addressing count 1.
Okay. Counsel? Mr. Reedy?
Your Honor, Mr. Cadeaux declined the services of the public defender.
Okay, sir, did you want to make an argument about probable cause? Can you say it out loud, because the recording can't pick up a head nod? Okay, thank you. I am going to find probable cause for the sexual assault. You've been charged with incest. I'm going to find probable cause. And there's a probation violation with a no bond hold. That hearing is set for a violation of probation for 6/11/18 at 8:45. Was there a recommendation for the bond on count 1?
Yes, Your Honor. Now that, based on the offense the court found probable cause for, it is bondable. Your Honor, I am concerned based on the allegations, also the strength of the evidence against the defendant, including but not limited to his admission. I'm going to be requesting and this was also, I believe it was done forcibly, Your Honor. I'm going to be requesting a $75,000 bond, no victim contact. He does have priors, including the cases on probation for, 2010, 2 separate possessions of cocaine with intent to sell and distribute with a violation of probation, delivery of cocaine, 08, possession of cocaine, 07, possession of cocaine, 06 for BOP.
Okay, sir, please raise your right hand. Do you swear? Can you raise your right hand? Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, do you have a place to live in the community?
No.
You could put your hand down. So are you homeless?
Yes.
Okay, and how long have you lived here in Broward County or South Florida?
All my life.
Okay, do you have any family or friends that could help you?
No.
Okay. Based on the answers, I do find him to be a danger to the community as well as with the nature of the crime. I'm going to set the bond at $75,000. Count two will be the $2,500. And count three is a no bond hold. You have a hearing June 11th at 8:45. Good luck to you, sir.
Your Honor, I apologize if the court already did. I might have missed it. Did the court order no victim contact?
I will order no
Oh,
victim
we
contact.
just
as
have him
well.
come back. I just want to make sure that he hears. Thank you, Your Honor.
Okay. Okay, sir, there's no victim contact as well, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind, no calling, emailing, texting, don't visit or even drive by the victim. And if there's something in the home, please, you must have somebody go get that for you. Okay? I'm sorry to call you back, but have a good day. William Rodriguez.
He's a medical research judge.
I have some trouble with that.
I did find probable cause. Actually, I'm not going to make that
We'll
determination
deal with
at
it
this
tomorrow.
time.
Yeah. Thank you, Judge.
Frank Stefanazzi. Okay, Mr. Stefanazzi.
I can't hear too good.
Mr. Stefanazzi, you have been charged with driving with your license suspended, failing to notify a change of address, disobeying and avoiding a red light, an expired tag, and altering the license plate. State, does he have any priors?
Your Honor, yes, he has, as far as Florida, a DUI from the mid-90s. I'm showing a warrant, Your Honor, out of the state of Pennsylvania from 2003 for failing to appear in court on a DUI.
Stefanazzi.
He's got at least one prior DUI out of the state of New York. Appears I was in the mid-90s as well.
Would you like to recommend an offer to resolve the matter?
It's a felony, Your Honor.
Oh, okay. It looked like it was his third. I didn't know you charged it as a felony. Okay, sir, would you, what's your recommendation for a bond, $750?
In light of the prior DUIs in the open warrant, Your Honor, I'm requesting the bond be kept in place.
Okay, counsel?
Judge, he is a lifelong resident of Broward County. At this point, he is unemployed. Disability is his only source of income, basically paycheck to paycheck. He lives alone in a trailer that he rents. Another concern that we do have is I've been advised his cat gave birth to kittens and is alone in the trailer with no one that could possibly check on them. So we do have a concern, and at this point, I don't believe he can afford the $750. I believe you said $150.
Yeah.
He has about $150 that he could use to bond out.
And $25 in my personal.
Okay, do you have any family or friends that could help you?
I do, but I don't have their numbers. I can't get to them. They all have cell phones.
Okay, is there something you could tell the public defender so that they can get in touch with them for you?
I asked Judge, he didn't know the numbers. And the alternative, they could ask for an order to access property for his phone if they're in the contacts, but again, we're not sure that they could afford, bonding him out.
Okay, I will reduce the bond to $500, and I will give you access to his phone so that you can get the numbers. And that way you could call somebody to help his cat as well. Unless, is there a process to call, like animal control or something like that to help feed the cats?
We've had that issue's come up before, and it can be difficult, Your Honor, because really, for instance, I don't know that animal control will.
Well, any animal organization.
I can make some calls and see. Did we confirm he resides at 435 South Federal Highway?
Well, if you could just give the information to the public defender so maybe they can do it on his behalf.
Sure.
As opposed to you doing it, I think it
appreciate
would make
that.
more sense.
Mr. Stefanasi, we need to confirm your address.
I appreciate that.
That he doesn't need to put on the record, though.
But make sure you confirm your address, okay?
With your co-counsel. Okay, Claude Randolph Charles. Good morning. You have been charged with failing.
Good morning.
Good morning. Thank you. You have been charged with failing to register your vehicle, possession of cannabis, and probation violation, which has a no bond hold, and the hearing is set for June 11th. State?
Your Honor, in light of the VOP hold, I'm just asking that everything be kept in place.
Counsel, did you want anything to be changed?
Judge, we were just requesting ROR on count 2.
Well, if I do
Seeing
that,
as
he
no
won't get
bond.
credit for any of the time served.
Understood. I,
No, I wanted the RR because I'm gonna
Judge,
be. I'm
we're still we're still requesting ROR on count 2.
Okay, I am going to find probable cause. I am going to do an ROR on count 1 and 2. Count 3 is a no bond hold. Good luck to you, sir. Lawan Funchess.
Judge, on Mr. Funches, count 7.
They send the court dates.
Yes.
This is a companion case. On the findings, can you put a B on the end, that case number?
There's already one written.
Can you put a B on it?
Yeah.
Yes.
Oh, somebody put
The clerk is working hard, working hard. Okay, sir. You have been charged with possession of a weapon or ammo by a convicted felon. Count 2, possession of a weapon or ammo by a convicted felon. Count 3, possession with intent to sell. Count 4, possession with intent to sell. Count 5, trafficking. Count 6, drug paraphernalia. Count 7 is the probation violation, B, with a no bond hold. There's a hearing on June 12th, 2018. State, was there any recommendation or priors?
Yeah, Your Honor, on count 1 and 2.
And I do find probable cause.
Thank you. On count 1 and 2, I'm going to be requesting a $10,000 bond and a $5,000 bond, noting that the charge he's on probation for is robbery with a firearm or deadly weapon and shooting at her, and there was a count of shooting at or throwing a deadly missile. On the trafficking, I'm going to be requesting that the $75,000 bond be kept in place. With the amount of fentanyl found, that there were guns also there, and just based on the nature of the drug in general, I do have a concern for community safety.
Does he have any priors?
The case he's on probation for, he has already violated previously last year for unlawful use of false name ID. Battery 04, end of record.
Okay, counsel?
Judge, at this point, we reserve any argument for the division judge.
Okay, then I will set bond. I will consider him to be a danger to the community based on priors and the violations. So I will set bond at count one, 10,000, count two, 10,000. I'll leave all the other the same, and he has a no bond hold on the count 7. Thank you. Calman George Bowen. Okay, sir. You were charged with grand theft. I do find probable cause. State, do you have any priors or recommendation?
Yes, Your Honor. He has, let me see if he has anything outside of Broward. 2015 theft. That's it. That's all I see, Judge.
Okay. Counsel, do you have any argument?
Judge, he's been living in Broward County since 1989. At this point, he is homeless. There's no one that I can call or get in touch with to bond him out. He is advised he cannot afford the $1,000 bond. I had asked for pretrial to allow him to call in. He did indicate. He does have a cell phone at his daughter's house. The $1,000 he would not be able to afford to bond out.
Can his daughter help him?
She's a 21-year-old college student, Judge. At this point, wouldn't be bonding.
Is he eligible for pretrial?
Take him. I understand she said that he was homeless, but we're not making any recommendations.
Will he be able to live with his daughter?
Well, technically, he doesn't need to have an address to be placed on pretrial release. There's nothing to prevent him from calling in twice a week just because he
Okay,
doesn't
we
have
just
a
don't want him
residence.
to violate pretrial for.
Right.
Well, Judge, he would have he could use the daughter's address if there's any mail or court notices or anything that would have to go to.
I'm not
But
as
he does have a
concerned with
phone.
that as that he'd be a flight risk because he doesn't have a place to live, but, or he violates pretrial by trespassing or something like that. State, do you have any objection to an ROR on pretrial?
No, Your Honor, at this point, I really can't raise an objection considering that his prior is a theft and this is a basically non-violent offense.
Judge,
Okay,
we could assist him in finding a residence in the shelter. If the court releases him, we could help him find placement.
Just,
I'm gonna ROR him, put him on standard pretrial.
and Your Honor, I've just asked for a condition of his release be no return to the Home Depot on 4th Avenue in Fort Lauderdale.
There will also be no return to the Home Depot. Okay, thank you. Winston Fisher.
You're welcome. Judge, he declined the public defender's office.
Okay, sir, you have been charged with driving with your license suspended, and it says habitual on it. Can I please have his driving record? And State, do you have any priors or recommendation?
Your Honor, I'm looking at his driving record. It's a lot of stuff on there. He also was arrested January of this year for a failure to appear. I'm requesting that the $750 bond be kept in place.
Okay, it looks like you were habitualized in 2016, so this, if you did resolve the case today, it would extend your habitualization. Is there any offer?
Your Honor, I can't. It's the way it's charged today is a felony, and so I'm unable to make an offer.
Okay. Sir, do you have any, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Do you have anywhere to live?
Yes.
How long have you lived there?
For about 7 years.
Okay. How long have you lived in South Florida?
My entire life.
Okay. Do you have any friends or family who could help you with the bond?
Yes.
Okay. So can you afford the $750 bond?
Yes.
Okay, then I will leave the bond at $750 and give you.
Excuse me, Your Honor.
Yes, sir.
I'm sorry. The
Go ahead.
750 is flat. The flat rate.
Yes.
750 flat.
When you say flat, I assume you mean a one-time payment? Yes. If you post your cash bond and your case is over, the money will go towards your court costs if you're sentenced. And if you are not sentenced because you're found not guilty, then you'll get your bond back, as long as you appear. Do you understand?
Okay, because the 750 is no 10% of paying 750, right?
Well, you could do that if you get a bondsman, yeah.
Okay.
All right, good luck to you. Have a wonderful day.
Thank you.
Sanjay David Campbell.
Good morning, Your Honor.
Good morning. You have been charged with carrying a concealed firearm, possession of cannabis, and driving with your license suspended, and I do find probable cause. State, do you have priors or recommendation?
Just from what I can tell, Your Honor, he had a possession of cannabis 2010, resisting without violence, trespass 2010.
Okay, counsel, did you have any argument on behalf of your client?
Not at this time, Judge. It's gonna bond out.
Okay, the bond is, on count one, is $1,000. Count two, I'll ROR, and count three, I'll ROR. Okay? Yeah, okay, I'm sorry. It was without knowledge. Thank you. Martise Terrell Pointer.
North Brown, John, he's a medical reset.
Okay, I will reset that. Then we have Alan Christopher Cadellis.
He's a medical reset, Judge.
Another medical reset. And then we have Nathan Lee Cole.
Mr. Cole's in North Broward, Your Honor. He refused to attend.
Your Honor, this is the second day in a row Mr. Cole's refused, so we decided to give him another chance to change his mind yesterday. Now that he's refused twice, I'm going to be requesting that the court make a probable cause determination that we proceed to having a bond set.
I do find probable cause.
Okay, Your Honor, to advise the court, as you can see, this starts with count 10. His other 9 charges involve three separate burglaries of subways, a missile into a dwelling where he threw something into a subway, committing the burglary. His bonds on the burglaries are set at $10,000 plus pretrial GPS. I'm going to be requesting the same $10,000 bond be placed on counts 10 and 12 with the same release conditions on all counts.
Okay, does he have priors?
Your Honor, yes, I'll check.
And counsel for the defense, did you have anything to argue?
There's really not much I can say, Judge. He's, I understand we gave him a chance from yesterday, but without having an opportunity to speak to him, there isn't much I can say. I mean, it's not a medical reset from what I'm told, so.
Okay,
I'm sorry.
counsel?
Yes, to advise the court, he has an open possession of cocaine that he was out on when these offenses were allegedly committed. Felony theft 2016, he violated probation, 15 months state prison. Theft 2016, grand theft, criminal use of personal identification information, 2012 with a VOP, 15 months state prison, and the theft in 2011.
Okay, on count 10, I'm gonna set bond at $10,000. Count 11 will be $100. Count 12 will be $10,000. Count 13 will be $1,000, and count 14 will be $100.
And Your Honor, going to place him on pretrial GPS on these counts as well?
I will. Pretrial 2,
Yeah, I believe it's level 2.
GPS monitor required. Okay, is there anything else to do this morning? Anything for the good of the order? No? Okay, well, thank you very much. And I will see you at 1:30.
Is it one, because,
Do you want to be here at 1:30?
usually they start the extradition at 1.
Okay, we'll be here at 1 for extradition. Do we have